So one of the power of the Supreme Court is to review its own judgment. So that is, it can be reviewed when the person who is affected by the judgment again approaches the court and puts a review petition. So review petition is provided under Article 137. There are three grounds under which it can be issued: discovery of new matter or evidences, mistake or error in the face of it, or any other reason which is analogous to the above. In addition to that, there is also curative petition, not mentioned in the Constitution, provided under it was invented by the Supreme Court in this case. So when somebody wants the judgment to be reviewed, they have to put a petition to the Supreme Court. That petition is called as review petition. As you were telling, no, that somebody is not happy with the judgment. So that time that person can put a petition in the court called as review petition. So this power of review petition is provided under Article 137. So under Article 137, the Supreme Court has the power to review any of its judgment or order. So the scope of review is by no means it is an appeal. Okay, when we say appeal, it can, as a matter of right, okay, go to the higher court. Okay, when it is given by the Supreme Court, when it is mentioned by the High Court, they can go to but this is not an appeal. Okay, the court is not allowed to take fresh stock of the case, meaning there is no arguments once again. Okay, it's not going to be like a regular court hearing. Okay, that's what I'm trying to say. It will not look into all the entire case once again. In review petition, it will not look into the entire case once again. Court is not allowed to take a fresh stock of the case. It is only allowed to correct any grave errors. Okay, under any of these three grounds, review petition can be filed. So you can put a review petition only under these three grounds. If there is a discovery of new matter or evidence which was not shown or discussed earlier, so suddenly they came across a new evidence that time when there has been a mistake or error apparent on the face of the record. Okay, so ultimately judges are humans. There could be some error which is very obvious. So if there is any error at the face of it, or any other sufficient reasons analogous to the above. I mean, it is very ambiguous, obviously. So ultimately, it is going to be decided by the judges whether to accept the review petition or not. Okay? So it is the judges only who will decide whether to accept it or not. Once they accept it, they will only take the issues that is leading to that conflict. Not the entire, they will not hear the whole case again, they will not call evidences, etc. Only those matters which is causing problem, they will discuss that. So this is review petition. It is mentioned in the Constitution itself. So curative petition is not mentioned in the Constitution. Okay, it has been invented by the Supreme Court. In this case, Rupa Hura versus Ashok Hura case. In 2002, the Supreme Court came up with this concept called as curative petition. So even after the final judgment has been given, and even after the case has been dismissed under the review petition, still it can be heard by the Supreme Court under the curative petition. So the curative petition is accepted when there has been violation of natural justice and there has been bias in the judgment. There has been bias in the judgment. They have to prove it. Then only this curative petition is accepted. Okay, natural justice is violated. So is it mentioned in the Constitution? No. It is evolved by the Supreme Court. Which case? Remember this, Rupa Hura versus Ashok Hura case. In this case, the Supreme Court came up with this, so they can entertain any court case even after review petition if the person who has been affected by the judgment proves that there is violation of his or her natural justice and the court has been biased in giving the verdict. Okay, in such cases, it can be accepted, that is curative petition. Okay, and curative petition should be accompanied by a certificate from a senior lawyer of the Supreme Court. The senior lawyer of the Supreme Court should, certify that this matter involves violation of natural justice, and the judges pass the judgment which has affected the petitioner. They have to certify it. Okay, and if majority of the judges, okay, in the bench agrees, then they will accept this petition. Then they